Okay, so the next slide I developed because I had a client who said these exact things. He said, my parents died in their sleep, um, and so I am not going to sign a power of attorney because I'm the patriarch of the family and nobody is going to touch my money while I'm alive. This was a couple of years ago, and I did finally convince him to sign what's called a springing power of attorney. There are two types of financial powers of attorney. One is immediate and one is springing. 99% of my clients get immediate powers of attorney. So what that means is you do not have to be deemed disabled or lack cognitive abilities in order for your agent to use the power of attorney. Of course, you want to, you need to appoint somebody that you really trust. The springing power of attorney, on the other hand, requires that a doctor write a letter stating that the grantor of the power, the holder of the power of attorney, is disabled and unable to make their own decisions. So the problem there is that very often we need powers of attorney in emergency situations, and we don't have time to go to a doctor. We're running to the bank to do something for them, or we have to talk to the insurance company. Something happens where we have to do it in an emergent situation, and we don't want to have to take our loved one to a doctor at that point and have the doctor deem them disabled. And this actually ended up becoming a crisis for them. This individual did descend into dementia rather quickly, and we ended up at literally the last moment having him sign the bottom of the power of attorney, revoking the springing portion of it and making it immediate, so that his son, who was a financial professional or is a financial professional, was able to take over for him. So we narrowly averted disaster in that case. So what happens when somebody does not have a power of attorney? And by the way, the one thing that really incenses me, and I see this over and over again, is people come in and they have their wills done by an attorney, but for some reason the attorney didn't pressure them into signing the other proper documents. So they're sitting there with a will, and they now do not have the capacity to sign a financial or healthcare power of attorney. So what happens when this happens? And you'd be surprised how often it happens. The family must seek a guardianship, and a guardianship is expensive. If it's not contested, it's very often $8,000 to $10,000. It is time consuming, takes months very often, and it's emotionally draining. And sometimes what ends up happening is the person that is appointed guardian is not the person that the individual would have chosen as their agent. So this is such a simple document to sign. They're simple to understand. They're inexpensive. I see no reason why everybody shouldn't have one of these documents. And as a matter of fact, now I have college-age children, and I am a proponent of having an 18-year-old sign a power of attorney, especially if they're going to school out of state, because many people don't realize that although we're paying for their education, we're not allowed to make any financial decisions for them without their acknowledgement or without signing a power of attorney.